The next thing we're going to talk about are the criminal consequences of the DWI, and really looking at what would be required as far as the sentence if convicted of a DWI offense. The substantial majority of DWIs are charged as misdemeanor offenses. There are ways for a DWI to become a felony charge. We won't talk about that in this video, but effectively the substantial majority are charged as misdemeanors. So there are 6 sentence levels for misdemeanor sentencing purposes. The most serious sentence level is a level 1A. And then there are 5 sentence levels, level 1 through 5, that level 1A being the most serious, level 1 being the second most, and then down on to a level 5, which is the least serious or has the least criminal impact. What a judge would be looking at if you were convicted of a DWI to determine your sentence level would be the presence of what are called grossly aggravating factors, and mitigating factors. DWIs have their own sentencing statute and their own sentencing chart, so they are not sentenced like most other misdemeanors. They have their own sentencing process. A level 1A through a level 2 would only happen if a judge found what is called a grossly aggravating factor. And a grossly aggravating factor could be an accident that resulted in serious bodily injury. It could be having a prior DWI on your record. It could be having a minor under the age of 18 in the vehicle with you, or having your license revoked at the time of the DWI charge for a prior DWI offense. So there are numerous ways that a grossly aggravating factor could be found. A judge would also look at what are called aggravating factors and mitigating factors. If there are no grossly aggravating factors present, then it's really the aggravating factors versus the mitigating factors that would determine a sentence between a level 3 and a level 5. Aggravating factors, or simple aggravating factors, would consist of having a high blood alcohol concentration, a 0.15 or above blood alcohol concentration. It could be an accident with $1,000 or more in property damage. It could be having a revoked license at the time of the offense where that license revocation was not related to a prior DWI, and there are others. A poor driving history could also be an aggravating factor. Mitigating factors include a low blood alcohol concentration, including a 0.09 or less BAC level, obtaining what is called a substance abuse assessment prior to your court hearing. It could also include safe driving at the time of the arrest. Basically, there wasn't any other poor driving. You're pulled over at a checkpoint or stopped for other reasons than driving. And so there wasn't any poor driving other than the fact that impairment was present. And then finally, a safe driving history being present, or impairment being not due to alcohol but to a medically prescribed drug that was taken in the prescribed dosage. All of these could be mitigating factors, and so if there are no grossly aggravating factors present, a judge would weigh the aggravating factors versus the mitigating factors to sentence somewhere between a level 3 and a level 5. Regardless of what grossly aggravating factors and aggravating factors actually exist in your case, we fight to keep those from being introduced by the state. Certainly we would not make the state aware of those factors. It is the state's burden of proof for any grossly aggravating factors or aggravating factors, and we also will help to make sure that the judge is aware of the mitigating factors that are present in your case.